Good afternoon, everybody, and welcome to today's session. For those of you who don't know me, my name is Jessica Blumenthal, and I'm a director in the Banking and Finance Department of ENSafrica. Some of you have been with us before on these webinars, but for those who are joining us today for the first time, allow me to just give some context to this webinar series that we're currently running. This webinar is one of 15 webinars that we are running from. We started in March, running right through April and into May. Originally, we started this webinar series last year. We presented the first series last year. And the purpose of the series really is to give back to our valued clients and to the financial services industry as a whole. We wanted to offer continuous professional development hours to the financial services industry to ensure that we assist in helping to develop thought leadership and push discussions further on critical legal topics of importance to our industry. This year, we decided to do something a bit different, and we've been presenting this year's webinar series with an ESG theme. And so all of the webinars making up the series think about a different ESG theme, whether under the E, the S, or the G, a different theme that is important under that umbrella of topics, but particularly important to the financial services industry. Today's webinar, presented by myself and my very learned colleague, Johan Loepscher, will deal with the jurisprudence of the Financial Services Tribunal. We'll take you through some of that jurisprudence and talk about what can be learned from considering that jurisprudence, and also really just to talk about what that means for your business as participants in the financial services sector from a governance perspective particularly, and things to take into account, things to think about when considering business risk. Perhaps just a few housekeeping points to note before we kick off. You are welcome to ask us questions. You'll see at the bottom of your screen a Q&A block. You can click on that and add your questions there, and Johan and I will attempt to answer them at the end of the session. There is also a chat block or a chat box, but please, if you can, put your questions in the Q&A. It's easier to keep track of them all there. Then, as I mentioned, this webinar, as are all webinars in this series, has been accredited by the FPI for a CPD hour, a single CPD hour. So if you do need a certificate at the end of this webinar, you will be able to receive one from our marketing team. But please note that you do need to stay on the webinar for the full hour if you are to be eligible for the certificate. So just bear that in mind and bear with us as we move through the webinar. Then, as I said, ESG is the focus for the webinar series. We have within our firm an ESG working group or practice group. It's a group made up of professionals from all the different departments within the firm. So it's a multidisciplinary group with deep specialization, all of us bringing our different skills together to ensure that we walk with our clients on their ESG journey. If you want to read any of the thought leadership or articles that have been written by this group, you can go to our website, and if you just search ESG in the search panel, you'll be able to find a roundup of all of those articles there. I think that was all of just looking at my notes, I think that those were all of the housekeeping points just to note before we kicked off. So I'm going to now share my screen, and then we will kick off with the presentation. Just do that quickly. Okay, something strange is happening, of course. Okay, give me 1 second. And does it also look strange on your side?
Yes, it does, Jessica. Maybe just share without presenting.
Yeah, let me do that. There we go. Apologies, everybody. Of course, it worked perfectly when we tested it 10 minutes ago, and now it doesn't want to work now. Okay.
And I've also got the benefit of seeing what's coming.
That is true. All right. So, as I said, it's myself and Johan Loepscher will be presenting this webinar to you today, talking through the jurisprudence of the Financial Services Tribunal. And before I create any more technical difficulties in the presentation, I'm going to hand over to Johan to get us started. No, what is going on?
Thanks very much, Jessica. Let me so just indicate to you briefly what we're going to be looking at. First, the legislative framework in which the Financial Services Tribunal functions. And then we're going to have a sort of quick look at who the members of the tribunal, as well as the sort of panelists are. Sort of a quick flip through the statistics of cases decided to date. The tribunal has been very busy and have decided hundreds of cases, and we have sort of looked at all of those to see if there's any patterns that are emerging and that we can highlight. And then lastly, we're going to look at some selected decisions relating to the decisions of the tribunal, with a view specifically as to what those decisions say about the functioning of the tribunal and its role and the way that it weighs up particular factors. And then we'll end the presentation with a list of matters and conclusions as to what can be concluded on a broad governance perspective from considering the decisions of the tribunal today. In relation to the legislative framework within which the tribunal operates, basically its powers and the manner in which it operates is set out in the Financial Sector Regulation Act, and that is then there's also specific rules which the tribunal has made that further regulates its process. The broad context within which the tribunal operates is that of the Promotion of Administrative Justice Act, where that act says that before a party may bring an administrative decision to judicial review, it must first conclude all internal remedies, and then reconsideration by the Financial Services Tribunal is one of those internal remedies that must in the ordinary course be concluded before a decision may be taken for judicial review to a court. In relation to the creation of the tribunal is independent. It must exercise its powers impartially, without fear, favour, or prejudice. And the Minister of Finance appoints its members, as well as the panelists who may sit together with the permanent members of the tribunal in deciding particular matters for reconsideration. And the basic requirements for the members and the panelists are that they must either be retired judges or lawyers, or they must have experience and expert knowledge of financial products, financial services, or financial instruments, etc. So it's either industry experts or lawyers then who may serve on the sort of panels of the tribunal. Members of the tribunal serve 3-year renewable terms, and the chairperson manages the work of the tribunal, appoints its staff, and makes its rules. And the chairperson may delegate to a deputy chairperson. And currently the chairperson is retired Constitutional Justice Yvonne Mkhoro, and the deputy is a retired Supreme Court of Appeal Justice LBC Harms. So how are decisions made by the tribunal? For each matter the chairperson constitutes a panel. The panel normally consists of 3 or more members, of whom at least one is a lawyer. The decision of the panel is the decision of the tribunal, and the members of the panels are appointed from a list approved by the Minister of Finance, who must advertise for applications every 5 years. And then what happens if members are divided on a particular decision? The majority makes the decision, except if they're evenly divided, in which case the chairperson of the panel would make the decision.
Thanks, Johan. And thank you for bearing with me through the technical problems at the start of the presentation. When we think about the panel and the as Johan has just described, and the tribunal, what's quite important also is to think about the process, because the process really does matter and is something that needs to be taken into account by anyone who is faced with a decision by a decision maker. We know that the Financial Services Regulation Act, the FSRA, says that any person who is the subject of a decision and who a financial sector law requires the decision maker to notify of that decision, that subject of the decision has the right to require reasons for that decision and to apply to the tribunal for reconsideration of that decision. And when a decision is communicated to a decision subject, both the right that they have to ask for reasons and the right that they have to apply for reconsideration, both of those rights need to be conveyed to the subject as well at the time that the decision is conveyed to them. Maybe just a practical point to note here is that most times the decision maker will provide reasons together with the decision, and that's certainly what is required of the decision maker. But to the extent that the decision maker does not, it is quite important for participants or subjects of decisions to always, as a matter of good governance, ask for reasons. And the reasons, certainly, it's a good policy to always ask for reasons and to consider those reasons closely so that you can make a decision as to whether it is necessary to apply for a reconsideration of that decision or not. The reasons, if reasons are requested from a decision maker, if they've not been provided, then those reasons must be requested within 30 days of notification of the decision, and the regulator or the decision maker then has 30 days after that request to provide those reasons. The time periods for making application to the tribunal then also run depending on whether reasons were given or whether reasons had to be requested. But so either within 30 days of receipt of the reasons or else 60 days of the decision, the application for reconsideration needs to be filed, unless at a later date, of course, it's also possible with condonation and if there is good reason for the lateness. What's quite important here, practically, is to bear in mind that these 30-day periods and 60-day periods that I've just described are references to days. So not court days, but days. The Financial Services Tribunal, in its tribunal rules, has also provided for a dies non period over the Christmas break at the end of the year. So essentially, in accordance with the rules, that period of time, it's usually from about the 15th of December to about the 15th of January. During that period, the tribunal doesn't count those days for purposes of its own time periods in accordance with the tribunal rules. But of course, the time periods set out in the FSRA, these 30 days and 60 days that you see on the slides, do continue to run. So if you wish to take a decision on reconsideration that was made in late November or early December, the 60-day period, which is the period in which the longest period in which you need to bring the reconsideration application, will run right through the Christmas period. And it's something worth just bearing in mind.
Jessica, if I may just add, a further reason why it's often useful to ask for reasons is, especially in situations where a decision by the regulators is against the license holder, is that sometimes in providing the reason, the regulator reconsiders the matter. Those reasons are often checked internally by the legal department, and in putting the reasons together, the legal department may alert the regulator to the fact that, in fact, the wrong decision was taken. And we have had situations where asking for reasons has led to a unfavorable decision being reversed and a favorable decision being taken.
Yes, absolutely correct, Johan. And I think another point on the asking for reasons and the receiving of reasons is we've also had situations where in the receipt of the reasons, we appreciated on behalf of the client and the participant, appreciated a different policy aspect that was at play in the decision making, which was not readily apparent from the legislation. So certainly it is an important thing to note. Okay, I'm trying to get the slides to move. There we go. Then when making application for reconsideration, there are specific forms that have been specified by the tribunal in its rules. So there is both a Form A, a B, and a C. And depending on the reconsideration application being made, the correct form must be used. The tribunal is quite insistent as well that the papers submitted to support the reconsideration application must be succinct. And so the drafting of the reconsideration application is quite important. The word succinct is mentioned 10 times in the tribunal rules, stressing that tight papers are required in order for tight papers are preferred by the tribunal, let's put it that way. Then another thing that sometimes eludes people is that a decision taken by the regulator is not suspended on account of the application for reconsideration. So if you wish to have a negative decision taken against you suspended whilst waiting for the trial date or the panel date for the reconsideration, then you need to make a separate application. A suspension application is made to the chairman of the Financial Services Tribunal, and it's decided on the papers. So there's not a hearing unless the chairman decides otherwise. That can be, the suspension application is obviously decided more quickly, and so on the papers, and so it can be decided in a matter of weeks, whereas the dates that the tribunal is busy setting down for tribunal hearings, if you were to try to set one down now, are already in October. So you can see how it becomes quite important to apply for a suspension of a decision in the interim period until the reconsideration can be heard. A suspension application can only be filed after the reconsideration application has been filed. So that can get tricky in that dies non period that I was talking about earlier, because you need to be sure that you've got the reconsideration application in, and then the suspension application can follow that. There's no appeal against a decision of the tribunal. So once the tribunal has taken its decision, the subject of the decision cannot appeal the tribunal's decision, but they can take it to the High Court for judicial review if the grounds are met. Johan, can I hand back to you?
Thanks, Jessica. So briefly on the jurisdiction and powers of the tribunal, there are some matters which the tribunal does not have the power to reconsider. So, for example, a decision by the Prudential Authority or the Financial Sector Conduct Authority to assess a levy, or the decision to conduct an on-site supervisory inspection or to launch an investigation, or any Reserve Bank directive to a regulator following a systemic event. I mean, none of those can be sent to the tribunal as a part of an application for reconsideration. And I also mention a couple of further examples in a moment, but let's just look at what the tribunal may do. It may reconsider a decision of an ombud, specifically of the phase ombud. It may, and of the pension funds adjudicator, it may reconsider a decision by any financial services provider to debar a representative. It may reconsider any decision by a market infrastructure that impacts a specific person. So, for example, if the JSE takes a decision that impacts a particular listed entity, that listed entity may apply to the tribunal for reconsideration. And then what it may also consider is any a specific decision relating to a specific person by the Financial Sector Conduct Authority or the Prudential Authority. And it may also bring for reconsideration to the tribunal circumstances where the relevant regulator has failed to take a decision which it is required to take. So, for example, if there's an application for a license and years have gone by without any decision by the regulator as to whether or not the license is approved or not, that can be brought before the tribunal for reconsideration. Notably, there's some actions by the regulators, notably the Financial Sector Conduct Authority and the Prudential Authority, which cannot be brought before the tribunal. So, for example, sort of a conduct standard or a prudential standard, it cannot be reviewed by the tribunal for its compliance with the relevant statutory framework. So if a affected party seeks to have a conduct standard or a prudential standard reviewed, it would have to take that application to the High Court. And then to be noted also that tribunal's power to make orders are limited. So for vexatious or frivolous or trivial applications, it can dismiss the application for reconsideration in a summary manner. And there are sort of a good number of examples where the tribunal has done this, which says, look, we've looked at the papers, there is simply no merit in this application and we are dismissing it without putting the parties through the need to respond and come for a hearing, etc. Where the tribunal has jurisdiction, for example, in relation to decisions made by the Financial Sector Conduct Authority in relation to a specific person, it may set the decision aside, and it may also remit the matter to the decision maker for further consideration. And an interesting fact is whether it is required always to remit the matter to the decision maker for further consideration when it has set the decision aside. And there are examples of practice by the tribunal where it sets the decision of the regulator aside without remitting the matter. So that's an important thing to keep in mind. It may make cost orders in exceptional circumstances, and then usually it may only substitute its decision for that of the decision maker in very limited circumstances. Those relating to administrative penalties, where it may, for example, reduce or increase an administrative penalty. Decisions by financial services providers relating to debarment. Decisions by market infrastructure such as the JSE. And then regulation could prescribe further circumstances in which the tribunal may substitute its own decision for that of the decision maker, but no regulations have been published as yet. As Jessica has laid out, the tribunal rules deal with an application to suspend the decision. And importantly also, the rules provide that leave is required before a application for reconsideration of decision of the phase ombud is permitted. And this is quite an important filter. The risk is that whenever the phase ombud says no, the complainant refers the decision to the tribunal. And what the rules of the tribunal permit is it to filter those applications for reconsideration in order only to consider, give leave to those applications where it considers the application to have merit. And we've certainly been assisted by that mechanism on a number of occasions where, it's clear that the complaint has no merit. The ombudsman has found so, but the tribunal is nevertheless seized with the matter because the complainant refers the matter to the tribunal. Here, just a quick list as published by the tribunal of the members and panelists. As you see from the advocates' titles, these are mostly lawyers, and I assume that there are also some industry specialists amongst them. Just a quick slide to summarize the decisions to date, and also perhaps to make a couple of speculative early conclusions in relation to the decisions to date. Let's take it from the left-hand side of the slide. So under the heading Phase Ombud, the left-hand column is the number of decisions where the Phase Ombud has been reversed, and the right-hand side, the number of decisions where the Phase Ombud's decision has not been reversed. There's a bit of bias in this statistic because of the requirement that the tribunal must grant leave for an application for reconsideration before reconsidering a Phase Ombud decision. So the only Phase Ombud decisions that come before the tribunal for decision are those which the chairperson thought, or the deputy chairperson thought, had some merit. So that's the reason, I think, for a high relative number of reversals of Phase Ombud decisions. And then there's also been an issue in relation to historic cases where the tribunal has been fiercely critical of the Phase Ombud's practice of deciding factual disputes on the papers and without holding an oral hearing or without relinquishing jurisdiction, by saying that a court is better placed to decide the matter. And that accounts for quite a number of the decisions against the Phase Ombud, where the tribunal was of the view that the Phase Ombud could only come to a proper decision if it held an oral hearing to determine the facts, which which was not being the practice of the Phase Ombud in the past. So that's in respect of the Phase Ombud. I'm not going to say much about the pension funds adjudicator. I think that sort of pension law and sort of the relevant decisions taken fall outside the scope of the decisions that we're going to be talking to in today's seminar. In relation to the FSCA decisions, this statistic is clouded a bit by the fact that included are all applications for reconsideration of debarment by financial services providers. So these 5 or so decisions against the FSCA include some decisions where it was actually a finding against the financial services provider in relation to debarment. But if one looks at both the statistics relating to the FSCA and the PA, which has never been reversed as far as we can tell, it's clear to us that there is a degree of reticence by license holders to apply to their tribunal for reconsideration of the regulator's decisions. And that degree of reticence may be explained by the fact that many license holders wish to maintain a good relationship with their primary regulator and are hesitant to litigate against the regulator in the tribunal, even in circumstances where there may be good grounds for difference, good grounds for questioning the decision taken against the license holder. But be that as it may, I mean, as the regulator is taking a stricter and more compliance-based approach, it may be that we see more license holders that are willing to apply for reconsideration of regulated decisions to the tribunal.
Thanks, Johan. Sorry, let me go back to that one. So thank you. I think that's been a helpful context of how of setting the scene of how the tribunal works, how the panel is, the members that make up the panel, and then Johanna obviously has just taken us through the split between the different types of decisions that have been taken on reconsideration. We're going to turn now in our presentation to talking about some of those decisions, selected decisions, and as Johannes mentioned, we will be omitting decisions relating to the Pension Funds Act. So we won't be talking about those, but we'll talk about sections of the decisions that have been taken by the tribunal, starting with, I'm going to talk a little bit about the decisions on the debarment of representatives under phase, because those certainly make up a large number of the decisions that have to be reconsidered by the tribunal. And then we will highlight, Johan will highlight a few other important decisions that have been taken and what they teach us in the precedent being created by the Financial Services Tribunal. So turning to debarment. Debarment as a process set out currently in the Phase Act, and as will be familiar to most of you, debarment as a process is quite a difficult process. It's obviously an internal process to be run by the financial services provider, and the structure of the Phase Act currently places an obligation on financial services providers to protect the consumer base, or at least protect customers and consumers from unscrupulous representatives or key individuals. And so to the extent that a financial services provider has reason to believe that its representative or key individual has either contravened a provision of phase or is no longer able to meet the probity requirements, so is no longer fit and proper, particularly focusing on the honesty and integrity requirements underneath the heading of fit and proper. If a financial services provider comes to that conclusion in respect of its representative or key individual, then it is required to debar that individual in accordance with the process set out in phase. But you can see how there's an inherent bias in that process, because the person having to make the decision, the financial services provider, is also the person who is the employer in most instances, person responsible for the individual who is under debarment. And so there can be a lot of procedural irregularity. There has historically been a lot of procedural irregularity and a lot of bias. And there is a lot of messaging, let's call it that, coming through in the precedent being created by the Financial Services Tribunal, underscoring that the debarment procedure needs to, at all times, as is required by the Phase Act, and of course by the guidance note that has been published on this topic by the FSCA, it must at all times be procedurally fair. So what it comes through several of the cases that have been decided by the tribunal is that FSPs, financial services providers, must always exercise their debarment powers within the framework of phase and PAJA. So essentially what that means is a FSP must pay close attention to the procedural requirements and make sure that at every step along the way that procedure is followed. It also comes through in the decisions that it's very important to pay attention to what it says in an FSP's debarment policy. And the FSP must act both in accordance with the Act and its own policy. And in many of the cases, the tribunal has pointed out that an FSP may have deviated from its policy, which of course adds an element of unfairness, procedural unfairness to the process. Then the tribunal has also gone a step further in some of the cases to try and supplement the process and to give some guidance to FSPs as to how that process could be made more procedurally fair. For example, in Everson's case, which is one of the important debarment cases that the tribunal has considered, the tribunal makes the point that appointing an internal person of an FSP, so someone within the FSP itself, to chair the debarment proceedings would of course have disadvantages. And the tribunal has stressed in that particular case that where there is at least a perception of bias, then an independent or external person should be appointed to chair those proceedings. So that's really just an example of the way in which one can glean further guidance as to how to ensure procedural fairness over and above that which is set out in the legislation and the guidance note published by the regulator from the jurisprudence of the tribunal. Then also importantly, and it also comes through several cases that have come before the tribunal, is this caution against abusing the debarment process. And as I've mentioned, the process is in a sense open to abuse. And so FSPs need to be very careful to guard against any allegation of this. So the tribunal has warned FSPs, as has the FSCA itself in its guidance note that I mentioned earlier, warned FSPs not to use debarment to settle contractual scores. If there is a contractual dispute between an FSP and a representative of that FSP, then that must be resolved in the appropriate forum. If disciplinary proceedings need to be taken, that must be resolved in the forum of labor law and in accordance with the employment relationship between the parties. Debarment is not an appropriate remedy in those instances, and that message has come across quite clearly in the tribunal's decisions. If one looks at Everson's case, for example, which is one of the debarment cases that the tribunal has decided, there was debarment by an FSP on the basis of theft of client lists. In that decision, the tribunal considered the process that had been followed by the FSP and found that process to be procedurally fair, but found that there were flaws or substantial unfairness in the decision that had been taken by the FSP. So in that instance, the debarment was set aside and remitted back to the FSP for a decision. Then again, in Osman's case, which is another one of the debarment cases, the FST, the Financial Services Tribunal, all the acronyms, very confusing. The tribunal has stressed that an FSP, when exercising their debarment power, must act reasonably and rationally. So the decision cannot be based on something other than a reasonable and rational decision based on proper reasons and a disciplinary hearing potentially that's been held, or some kind of finding by the FSP that representative has either failed to meet the honesty and integrity elements of the fit and proper requirements, or has contravened FAIRs in a material manner. And I should probably just pause there to note that, interestingly, and maybe just something to keep an eye on, the Conduct of Financial Institutions Bill, which is currently a bill and slowly making its way toward becoming an act. That bill, once it is an act, has a section dealing with debarment, which will replace the debarment provisions that currently sit in the FAIRs Act. And those provisions are very similar to the FAIRs provisions, so nothing too materially different, except that they add probably two important principles to the debarment. The one is that a representative or a key individual can, once COFI is enacted, be debarred for a third ground. So obviously we've said contravention of FAIRs, we've said not failing to meet the honesty and integrity elements of the fit and proper requirements. And a third ground that has been added is a failure to comply with the FSRA, the Financial Sector Regulation Act, which of course expands some of the principles applicable to financial services providers and thereby to their key individuals and representatives. So just something to note. Another interesting element that the Conduct of Financial Institutions Bill brings in on debarment is that the FSP, before it takes a decision to debar a representative or an individual, must ensure continuity or business continuity for its customers. So that is something that has not previously been part of the process set out in FAIRs, but will, once the COFI is enacted, specifically be required of financial services providers before they take the debarment decision, and they'll need to be able to stipulate and specify how customers will be protected against, for example, a representative who is suddenly removed and no longer able to service them. On the screen, you'll see some quotes from some of the case law, really just reiterating this point that I think I've made previously, which is that FSPs must be cautious not to effect debarments in instances where there is another type of inquiry that should have been conducted. So it should never be the case that a debarment is the sanction for a contractual or other grievance. It must always be a separate inquiry whether the debarment is justified, and that inquiry is against, as I said, whether there's been a failure to meet the fit and proper requirement or there's been some kind of contravention. The purpose of the debarment comes through in that second quote, and that's, I guess, where I started when I first started talking about debarment, and that is that the purpose of debarment as a regulatory instrument is to rid the industry of incompetent or dishonest representatives. That's what FSP is supposed to be using the debarment process for, and the tribunal's been quite strong in underscoring that in several cases, and in this Safike's case that I've quoted, the tribunal came out quite strongly to make that point. That's where that quote comes from. Another point that comes through, and that's quite useful precedent being created by the tribunal, is that a single act of dishonesty or negligence or incompetence or mismanagement is not in and of itself enough to found a debarment or to create grounds for a debarment. So what the tribunal is stressing to financial services providers is that if a rep or a key individual is guilty of some misconduct or has perhaps breached some element of an employment code of conduct, something along those lines, then there are essentially two inquiries. The one is to ask whether there is grounds for debarment, whether there's been a contravention of the act or there's a failure on a fit and proper level. If you are in the fit and proper space and the FSP is trying to decide whether the individual has lost the ability to call themselves honest and with integrity, then it is, according to the tribunal, not enough to place emphasis on a single act of dishonesty. And the FSP would be well placed to consider the individual before them more fully to decide whether their misconduct is such that it has actually impinged their character. This I have already mentioned. These are the grounds for debarment that I was talking about. I think what's important to take away here and what the tribunal have added in the Williams case that you see quoted there in the second bullet is that if there has been a contravention of phase, and that is the grounds for debarment, it must be material. And that's an interesting addition by the tribunal, an interesting emphasis by the tribunal, something to be borne in mind. Then, as I've said, if there is a failure from an honesty or integrity point of view, it needs to be such that it impinges the character of the individual, such that they are no longer able to meet the fit and proper requirement. It cannot be a single error or a single element of misconduct. And I think maybe just to talk briefly of Osman's case, there the individual in question, on the incorrect advice of colleagues, affixed a signature to a KYC form. Those were the grounds that were under consideration, and the tribunal in that case decided in favor of the individual that, in fact, whilst that was an error which the individual had admitted and potentially misconduct in terms of the employment relationship, it was not sufficient to constitute grounds for debarment. And those types of examples coming through the cases are quite instructive and helpful for FSPs, particularly when applying the law in their own instances. Johan, I'm going to hand over to you to talk about something other than debarment for a while, and just to draw some other lessons from the precedent created by the tribunal.
Thank you very much, Jessica. So, sort of quite a number of the decisions of the tribunal deal with the Shemax debacle. And it's interesting how similar cases with slightly different facts have led to different outcomes. before the tribunal. So, for example, in sort of cases of Baker, Nell, and Ernest Fenter, the tribunal found against the financial services provider and upheld the FAIR's ombud decisions that they should pay damages to their clients because of failings in the process of providing financial advice. So, for example, in the one case, the tribunal found that the financial service provider could never have recommended the scheme in a responsible way because he failed to inform himself about the facts relating to the scheme. In another, the tribunal said, look, if you merely providing the client with a registered prospectus of the scheme falls far short of fulfilling the duties in the general code to properly inform the client of the nature and risks of the investment. And interestingly, in this sort of Ernest Fenter case, the tribunal also said that the financial service provider should have known that there existed under the Unfair Business Practices Act a notice setting out requirements for property syndication schemes. And the financial service advisor should have compared the prospectus to that notice and the requirements in the notice. So sort of a fairly high standard of care required of the financial advisors in those circumstances. And of course, the financial advisors did not do themselves any favors by sort of tripping themselves up on the most basic elements. They didn't keep records of advice, for example. Very difficult to convince the tribunal that you've acted properly if you can't show, for example, that you've kept a record of advice of the advice given. If you go to the next slide, please. Just some further bits and pieces relating to the Shemax cases. Interestingly enough, in the last case, Peter Kronier Makelaars, there the tribunal found in favor of the financial services provider and vacated the decision of the FAIR's ombud. And the facts there was that the relevant investors had themselves done a bit of due diligence and attended meetings held by Shemax in respect of the proposed investments. The investors had specifically acknowledged receipt of the applicable documents and the prospectus for the investment. They elected to seek a better rate of return, knowing full well that came with greater risks. And the record of advice showed that they wanted truncated advice from the financial services provider. And all that served to show that in this case, the financial service provider should not be liable for damages. If we could perhaps go to the next slide, please. Just on the question of administrative penalties, it's quite important to note that the tribunal has the power to either send back for reconsideration a specific administrative penalty imposed by the regulator, or to reduce the penalty as to what it would regard as being appropriate, but it'll only interfere with the penalty if, in fact, it finds that the regulator erred in imposing the penalty, whether in considering the relevant factors or in considering the relevant facts. So it'll only interfere if it can point to an error made by the regulator in the first instance. It will not simply supplant its discretion for that exercised by the regulator. Perhaps just to mention the case of Fern Finance. So in that case, what happened was the regulator took enforcement action against a firm on the basis that it required an insurance license. And the lawyers acting for the firm wrote a very aggressive letter to the FSCA denying it had jurisdiction and threatening it with a claim for damages. And this was taken by the tribunal as evidence of the fact that the key individual of the firm was not fit and proper and had contempt for the regulatory scheme. So in that case, the lawyer's letter counted against the firm when the facts were considered by the tribunal. We could move on to the next slide, please. So the case of Marcus Jooste and the large fine imposed upon him and certain of his acquaintances for violation of the insider trading prohibition is it's a very interesting one. Just on the facts of that case, Jooste sent an email, an SMS to some acquaintances saying that they should sell Steinhoff immediately. And the question to be considered by the tribunal was whether that SMS was specific and precise enough to constitute the sharing of inside information by an insider. And the tribunal found that it was not specifically sufficient and precise, but the way in which the Financial Markets Act is drafted, it's also a contravention if a person that is an insider encourages others to buy or sell listed shares. And the tribunal found that clearly the SMS was from an insider and did encourage dealing, and therefore that constituted the contravention of the Financial Markets Act. Interestingly, also the tribunal was not satisfied with the way in which the penalty was set by the Financial Sector Conduct Authority and made an aside observation that the maximum penalty set out in the Act shouldn't be used as a benchmark for an appropriate penalty in each instance. If we could go to the next slide. So what's clearly emerging is that the tribunal is cognizant of the fact that it's the Financial Sector Conduct Authority and the Prudential Authority that is given the task by the legislature to regulate the financial sector, and that it's not the tribunal's role to impose its own policy preferences in reconsidering the decisions brought on application before it. So there's a number of quotations one could point to in the tribunal decisions where it says, look, where a decision is multifaceted and polycentric, we're going to defer to the regulator. I mean, our role is to check whether administrative process and fairness has been properly applied, and whether the regulators have properly applied the law. But we're not going to substitute our policy preferences for those of the regulator. If we go to the next slide. So just an interesting fact in relation to exemption applications. So one of the exemption requirements under the FAIS Act is that evidence must be led of hardship for the applicant. And here the tribunal has clarified that that the applicant for the exemption must show that it is subject to greater requirements, or that the impact of the requirements is excessive in relation to its position compared to other persons. One can't just complain of a requirement and for that reason seek an exemption. If we go to the final slide, please. Let's skip that. So some thoughts on what our reading of the tribunal decisions has led us to conclude relating to the governance of financial institutions. So in the first instance, I think it's important to note that the legal requirements as they are written matter. It's that what the tribunal is going to consider in reconsidering a decision by the regulator. So one should be very careful to rely on practices which are in conflict with the law as it's written. Secondly, be polite and respectful, cooperate with the regulators. It can count against you on a reconsideration if you fail to act politely and with respect, and if you fail to cooperate. Do not pass up the opportunity to place the facts before the decision maker. So a large number of the decisions, the regulator finds against the license holder simply because it has not, the facts have not been placed before it, which allows it to find in favor of the applicant. Next, it's important to set out the applicant's interpretation of the law when dealing with a regulator. When one must accept that regulators are busy people, that their legal departments are overburdened. And it's often worthwhile to set out expressly the interpretation of the relevant law the financial institution is relying on when dealing with a regulator. Then one should accept that the tribunal follows the legal requirements, and it's unlikely to simply replace policy decisions of the regulator in considering applications for reconsideration. It's very important to comply with the formal requirements, also to be able to approach the tribunal with clean hands, to keep the proper record of advice, respond within the timelines, respond fully. And then the last thing, which Jessica and I have come to realize when we prepared for this seminar, is that the tribunal expects its decisions to be read as precedents. There's an old adage that a good lawyer must not only know the content of the rules, but also how they are applied. And I think the financial services community as a whole will be well served by looking at these tribunal decisions in order to see how the tribunal applies the law. There were quite a number of surprising matters that we saw in reading the decisions.
Thanks very much, Johan, and thank you for summing that up for us. And we thank you very much to everybody for your time on this webinar today and for joining us. And we hope that you did learn something new, or at least felt compelled to go and read the tribunal decisions and to really engage with them. Johan, sorry, I think did I cut you short? I see your hand is up.
Sorry, no, I think that is just a technical...
We had to have one last technical glitch at the
end. I just confirm that we have not received any questions, so I think we can conclude, given that our hour is up.
Yes. Well, thank you very much, everybody, for joining us. As we play out now, you will see on your screen a list of the upcoming webinars. And just a reminder that if you do want to attend any of those with us, you can email marketing@ensafrica.com. The email address is on the slide that you'll see as the webinar ends. Thanks very much. Bye-bye.